G'day mates from Australia, and welcome to the weekly docket.
Hey guys, good morning. And of course, we did a stream last night, so we covered some ground. So we'll get right into the cases this morning. Although there are several updates that are kind of interesting. Hey, that was a pretty good intro, wasn't it? At least the guest intro narrator. That's my favorite part. Good morning to Oklahoma, and I believe that's Connecticut, Missouri. You guys are all over the place. Love the y'all. Nashville, of course, hard to beat. I like seeing that. It just reminds me I got to play the guitar when it gets evening time. So anyway, let's get you guys into the game here and see what's up and what questions you may have. Little Sweden, USA. That's cool. Washington State, home of Mount Rainier, which is quite awesome. Arkansas has more interesting things in it than people would think, doesn't it? And little Sweden. So, all right. So let's start off with Alex Murdaugh, the North Georgia mountains, Texas, Illinois. I can't even hit all these things. You guys are everywhere. What's going on in this case, right? And Germany. Okay, yeah, that's cool. Because when I was young and went over there for the first time, I was in West Germany. Near Bad Tolz. So some of the pictures yesterday from that. Anyway, of course, he's got this writ of prohibition going where he wants Judge Newman to not hear any more of his cases or even the motion for new trial, right? We went over that last week. So what's happening now? Well, we do have some action. But still, I got to catch a couple of these things. We got Alabama, Kansas, Santa Fe. Man, you guys are making me want to put some gas in the car and get on I-40 West, like we used to do. So Clerk Hill denies all these things that were said, that she said, all right, that she was telling the jurors this and that about how they should handle the case. She says, I didn't do any of that. And her affidavit, I only put part of it here, covers that in detail, that she just didn't say these things, she says. And that's not surprising. I think it had been an indication that she was going to deny this. Now, she denies it. There's affidavits that are contrary to that. It makes you think that if that's important, whether she said it or not, then an evidentiary hearing would be likely. Okay. But I think the battleground on this is more significantly on what's the standard. Because when I read some of what the state came back with, I saw them saying that, hey, the jurors were not influenced. Well, that's important mentally, and it may be important legally. But when Murdaugh's team filed his documents, they were citing cases that said when it's a court actor, you don't need to test whether the jurors were actually influenced or not, just whether the topic was such that it could impact the case. And the state, of course, does not agree with that analysis. And I've got the logo here for Fitz News because they're going to have a program, I think, that drops this sometime this morning on YouTube with an expert on this to talk about this. So I'm certainly going to listen to that later. When I saw that they were doing that, I didn't go read all the cases, but I think that's the battleground for this because otherwise you get a you get a new trial. And I think they've made a reasonable case for that in terms of having this hearing. Will it be Judge Newman? And will they do the evidentiary hearing? And then what standard do they apply? What's the legal standard that's applicable here? So that's what's going on in that case. But again, check out Fitz News when they drop their video today. I think that will have some interesting insight if you're interested in this case. Am I saying that wrong? I'm calling it Fitz News. It's Fitsnews. So right now, it may be a matter of he said, she said, although I think Murdaugh's team are saying that they have some evidence that she said this stuff. Of course, she's saying she did not. So, right. And of course, a lot of cases are he said, she said, and this is no negligence case or criminal action in and of itself. This is for the court to determine whether there's going to be a new trial based on this. So I'm not even sure what the burden of proof is for the judge to decide whether this did or didn't happen in this particular instance. And then whether the judge needs to look at, well, did it happen? And then also, is there any inquiry or the ability of the state to rebut that this actually influenced jurors, which is the standard for some other types of communications. But when it is a court actor, there definitely is case law that is not treated the same as just some random encounter with somebody. So that's what's up there. You got a vet in here, and thank you for what you've done. Again, my stuff was just to point it out. It was a positive experience for me, not like I did anything. Wasn't necessary for me to try to even do anything to save the country then. So no applause for that, but it was something that was great for me in life, that's for sure. All right. Yeah, Charlotte and West Germany are two different things, but it's interesting there, huh? Because you were close to West Germany, and Charlotte is close to Raleigh. But it used to seem worlds apart, not so much in the state. I had Brian Koberger on the thumbnail for this video thinking something big was happening, and I'm like, well, what was it big that was happening? You know what? I'm not sure that we haven't. I think we've covered all the big things that are happening, and that's probably due to the stewardship of this judge, maybe born to the position, huh? Who I think, as I said last night and I've said before, so far in this case has been very balanced, very measured, and handling the case very well. And that's the judge's job, right? But I'm going to give some credit to the state and the defense team here for handling that case, I think, in a professional way. That's my opinion, how they're approaching this. And sometimes they make good arguments. Sometimes either side makes a poor argument. The judge takes it all in stride and deals with it, has, I think, insightful and sometimes good-natured banter back and forth with the attorneys as he's trying to suss out the merits of their arguments. So at least from a lawyer perspective, I really enjoy watching him work. He's the kind of judge that is a pleasure to appear in front of, versus sometimes it's not like that. But he's doing a great job, I think. Now, this case we went over last night in some great detail, so we won't hit it again. But I will say, the people in the chat and comment since have had a lot of, I think, great comments in terms of how this looks bad for the court system, and then also on the merits of the case, which we didn't do. But just to recap it, there are two original actions in front of the Supreme Court now calling into question some of the things the judge has done. The first one filed was mostly entirely geared at documents not being available to the public, and also her decision to ask the clerk to strike things from the case record as well as from being in the case file. But then, of course, we had the subsequent hearing, and she said, well, I'm not only saying you withdrew, I am saying you're disqualified from being in this case, even pro bono. You can't even appear pro bono. That's a much bigger deal. And now there's an original action on that saying that she was improper for that. The Supreme Court of Indiana will have to look at that. So they're asking that the original attorneys, Baldwin and Rozzi, be reinstated, that the judge be removed from the case, and for a speedy trial date to be set. I don't think they're going to get all those things, but if I were setting up there, I'd probably be leaning right now toward granting some of it in terms of the original attorneys. Well, look at all these places. North Carolina has beer everywhere. I'm looking at this beer comment from Germany because, of course, Germany's famous for beer, right? And that's where I had my first beer, was at Oktoberfest in Munich. But now North Carolina has a brewery on every corner, so this is a beer state ourselves for sure. So anyway, in this Allen case, we have response due from the judge on the original action, the first original action on the 16th, and then also on the 27th, and that is for this action to reinstate the attorneys and get her out of the case. But it's also for the transcript, because in that second original action, they asked the Supreme Court to order the transcript be provided from the in-chambers hearing. So when the defense is asking for that and the judge is saying, I don't want to do that, it really makes you wonder whether it totally supports the judge's basis for doing this. Because if it was just embarrassing to the attorneys and she was sparing them the embarrassment and they're asking for it to be put out in the public, why not do it? So I don't know what it says, but we may find out. But this is all tilting toward the defense, I think, at this point, for purposes of this procedural stuff, which is important. All right. Charlie Adelson, his sad story that he gave, unfortunately landed on planet Earth. And on planet Earth, it's hard to find people dumb enough to fall for what he was trying to sell. It didn't happen. And so he was convicted. And then he told the judge, hey, they set up a chat group that an alternate juror told us that some of the jurors had a text group, some chatting of some nature that wasn't, I think, specified. And this judge, I don't know what he looked like when he said, I'm not going to get into this, but it probably had that expression on his face there, as you can see. He was another one. I enjoyed listening to him as he was running the case. I thought he was doing a good job. So let's see here. I see one thing. It says it's not going to happen. There's still an open investigation. So I apologize. I missed what you're talking about in that. And so if you tell me, I'll be sure and comment on that. All right. So let's go to Chad Daybell. He didn't make the thumbnail, but he's got some action happening in his case, some actual activity. And he's trying to get the death penalty out of the way. He doesn't want to be killed, even though he's this multi-life super prince hero that strides across the eons, a master of all he surveys as he moves through time and space. But yet he has a real big problem with, he'd rather sit in jail for a few decades than have the death penalty and get to his next life where he could, continue to rule the world or whatever. He didn't bring any of that up that I saw in his motions. So here are his actual theory. Here we say transcripts. So I feel like there'll be a transcript of the in-chambers hearing. However, the judge is ordered to either produce the transcript or produce why not. Now, we haven't seen what she's saying for why not. There could be some reason that would support not providing it, but I feel like you don't throw the attorneys off the case with a conclusion of how they've behaved if you don't put that behavior on the record. And so that's my take on it. But we will know soon. The Supreme Court there is not going to let this drag out but so long past Thanksgiving, I guess. But that's it. All right, back to Chad Daybell. So he wants the state limited to consistent theories. And he's saying that when you prosecuted Lori, you said that she was kind of, to some degree, the mastermind of this, that no one would have murdered anybody if she weren't driving the train, if she weren't driving the car or whatever. I think you just conduct the train, but whatever. So she was the leader of it. And he's saying that you can't act like now that I'm the ringleader if you said she was the ringleader, and has some case law to support that the state should be consistent when it's prosecuting people for a crime like this. And he's saying, therefore, you need to strike the death penalty based on relative culpability. I'm not, if to the degree that I may be found guilty, I'm not worse than her because you said she was the ringleader. She was the prime mover in all of this. And at some point they said the punishment that the state sought, but later on they also talked about that it was subject to a discovery sanction, because I'm like, but they did seek the death penalty for Lori. So then in theory, they should be able to seek it for you too, because he's saying you can't ask for a harder penalty for me than you did for the person who was the ringleader. But he also has some case law saying that sort of thing. And then also saying that the discovery violation that occurred that warranted the striking of the death penalty in Lori's case was also applicable to him. He says, I didn't go into detail on that, and therefore, he should get the same remedy. And that's basically his arguments here. So the three motions are all saying, you can't treat me worse than Lori, basically, is what he's saying. If somebody really believed in reincarnation, you'd think they'd lobby their own death penalty, right? Yeah, remember that movie with Tom Cruise in it, Emily Blunt, and they kept getting reincarnated all the time until they finally won the war? So, yeah, that kind of thing. I agree. All right. So let's go to the civil side a little bit. If you watch this case, the Maya Kawalski case, I didn't see all of it. I saw some of it. At the very early part of it, I thought, I don't know about this. If the plaintiff's lawyer is going to really get this to the jury in the way they need to hear. But then as the case moved on, I thought this guy is picking up momentum. He's scoring some points. And then every time, with the exception of once, when I would listen to a defense witness speak, I thought, could these people come across any more arrogant and smug than they were? And we talked about it a little bit on Eric's panel yesterday, the reptile theory of litigation, where one of the things you want to do to enhance your damages is not just present your damages case, but cause the jury to become so angry and upset at the defense that their anger and upsettedness and seeing the defense as a danger, it flows into the damages calculation and you get a higher award. Well, the defense was doing that to themselves a little bit, I think, in terms of essentially taking no responsibility for anything. And they pushed all their chips into one corner, kind of, which is they were faking this. So the jury didn't buy that, right? So now we have a gigantic verdict. And what are some questions on that? So when you get a damages award in a case like that, you have different categories, and there's compensatory. In other words, restoring you for what you lost. The simplest scenario is somebody backs into your car and damages a bumper. They pay to get you a new bumper to fix it, and then you're back where you were. That's how that works. So you have the kind of economic damages. Hey, I wasn't able to go to work for this amount of time, and this is what I make, so I lost this. Or I'll never be able to make as much money in the future because of this thing you did to me, so I've lost this earning capacity. I've got all these medical bills sitting around, and also ones in the future. And then non-economic, which is the pain and suffering, disability, things like that. What's all that worth? And is that up to just a jury to decide for the most part, right? There's no real calculator for that. In the old days, for simple car accidents, the rule of thumb was to, 3 times damages, or 3 times the actual damages and bills and things you get for pain and suffering. But that was no written rule. That's just was a guideline that people kind of thought of when they were thinking about cases. But if you take a case to trial, it's up to the jury. And in a situation where it's not some simple car accident, but something like this, things can get quite out there, as they did happen here. And then, of course, punitive damages, which are designed to punish the defendant. What about limits? Because different states have limits on what you can get. Particularly here, you hear about that for punitive damages, the runaway jury that you want to stop. And sometimes that's a reasonable goal to have. So it doesn't just destroy companies and forum shopping to go get a jury that will give you this and stuff like that. So basically speaking, on direct compensatory damages, lost earnings, and my car got damaged by this much, or you caused me to have this bill. There's not a limit on that, because you need to show what those bills are, that loss is, and whatever you caused, you caused. Now, on the non-economic side, Florida was concerned, especially in medical cases, but also some other ones, that juries were giving away too much money. And so it was costing more money in the medical system and other things like that. You understand that argument, but the Florida Supreme Court said, no, we're not going to let you do that. So now there's not a cap on non-economic damages. And the non-economic damages awarded in this case were quite high, right? Very high. And I see this comment here, the jury went easy on punitive, and they did relative to, let me put that up, relative to the award on the compensatory side. That's right. So Florida does have statutory limit on compensatory damages, but it's staged, and it depends on how intentional it was. And it can go from 3 times to 4 times, or not at all. Although the Supreme Court has some theoretical limit on punitive damages. But as you say, that didn't really factor in, I don't think, into this case. I don't think the punitive awards were in excess of any potential limits that they've got here. But that doesn't mean that the defense has played all their cards yet. Although they played a terrible hand at trial, didn't they? Wow. And when the plaintiff's lawyer would get up and go, I get it, you get it, they still don't get it, I thought, you know what? I'm thinking you're right on that from listening to these people. And that's aside from whether the award should be $1 or $200 million or whatever. I don't think they got it. And that doesn't even say that they were necessarily wrong in everything they did, but institutionally, they seem to me to exhibit a great deal of arrogance of everything we do is right. And if somebody disagrees, you must suspect their motives. It must be fraud by the family, fraud by the patient, because, what we do is just so great. So do I think more people will come forward and sue this hospital is a question. I think maybe there are some other claims and cases. But if you're a plaintiff's lawyer, you are looking at this closely, right? And you're not only looking at what the jury did here, and then also knowing that everybody's heard about it, so that helps you if you bring a claim. There are other factors involved in this. For example, it's not like, which we'll get into this in a moment, it's not like they, at the end of the case, they go, well, here's your check for $200 and whatever $million. So the defendant, there's the effort of getting the verdict, and then there's the ability and effort to collect. You got to calculate that all into whether a case is quote unquote worth it or not economically. So let's see a little bit of that. What's a losing defendant to do? So I would think the first stop on that would be they file, various post-trial motions that they can do But one of those is you can ask the judge to remit the damages. So let's make up a case. Let's say that, I ran into your car and it caused $1,000 worth of damage for your bumper, and that's it. You weren't in the car. You're not hurt or anything, but I don't want to pay for it. The jury gets mad at me and they award a damages amount of $5,000. So then I would ask the judge to remit that damage amount down and say, Judge, even the plaintiff only asked for $1,000. That's all the plaintiff put into evidence. How can there possibly be an award against me for $5,000? And then in that case, the judge should go, okay, you're right, and move it down to $1,000. Now, this statute that I'm putting here talks about the procedure if that happens. If the other side doesn't like it, you can get another damages trial, not the whole trial, just the damages piece. But the judge can reduce a damages award if the judge thinks it's not supported by evidence. And there's some factors listed on here, like if they did it because of prejudice, passion, or corruption, things like that, ignored the evidence, took improper elements of damages into account. So, if the judge thinks these things, the judge has the ability to reduce the damages amount. So if you think it's too high, which I'm sure the defense does, your first remedy should be to ask the trial court to reduce the damages amount. I don't know that the judge is going to do it or not, but I think there's a little reptile theory here in that the results were so bad for this family that if you hold the hospital responsible for that, then it bleeds back into the damages component that it's a lot of money because of how bad the situation was. A lot of money on each one of the claims that they had. And somebody says, Mr. Anderson has another case against them coming up. I'm not surprised if you've done one. Doing a second one is easier. And I think they're going to file some other claim, they said, on Maya's behalf for assault. So, yeah. So anyway, that's the first thing you do is try the remedies you have at the trial court level. You're not stroking that check right now, right? And I've heard that I don't think they even offered to settle. Now I get that you don't want to open the floodgates, and we're an easy mark and all that. On the other hand, if you can get cases to go away and deal with them and say, look, we've gotten rid of all the people that did that, we've changed this, we've made this family whole, we're a different entity now. A new team, if they get one, might want that kind of clean slate versus continuing to fight the last war. So on appeal, you're going to ask the appellate court to deal with theories of liability. And I think the defense here has a few that they were bringing up, at least that I heard of. I didn't read all the case file or really any of it, but I know they have a proximate cause issue with whether they can really be responsible for the damages for what happened with the mother. I'm not supposed to say these words anymore on YouTube, but from what I understand, that's stupid. We're adults. We should be able to talk about things, but there's a proximate cause issue there, I think, potentially. I wouldn't want to rely on that to not have to pay now, because I think sensibilities are changing on this issue, that some acts by people can drive people to extreme actions against themselves. I think that's accepted in a lot of quarters. It certainly was by the jury in this case. So we'll see, I guess. Then there's the issues in litigation at trial. Hey, the judge in a motion in limine made the wrong ruling, and that infected the trial. At the trial, the judge did this thing wrong. The judge gave a jury instruction that had the wrong burden of proof in it, that kind of stuff. And then the damages awards. You can say, well, in the last instance, Court of Appeals, you can't give somebody, $19 million because they somebody picked them up and put them on a lap or even kissed them or whatever. They're going to say that even if all the evidence is there to support liability, that amount is excessive. And everybody can have an opinion on that. The question is, will the Court of Appeals go, yeah, a jury can't do that, we're going to bring this damages down? But certainly you would argue that, right? So sometimes while cases are on appeal, before the appeal's decided, they'll settle then. Like, look at Depp Heard, right? So that's why I've got this comment down here. It's a long way from a verdict to a check, and it's never too late to settle. So who knows on this? But eventually, this could be dragged out for years to the Court of Appeals in the state and then to the Supreme Court of the state. But an unpaid money judgment also accrues interest. So eventually some resolution has to be sought. So we'll see what happens with it. Maybe, it's always possible they could reach a confidential settlement or something. And sometimes wiping the slate clean and bringing in a new management team that can then have, some kind of reduced settlement with these people and say how sorry they are. And then that lets everybody get this over with. It could be the way that this ends up happening, but I would normally say you wouldn't want to be defense counsel here, but they're billing by the hour. So even when they lose, they win. Not that I'm accusing them of doing that on purpose, but as long as they maintain the confidence of the hospital, then maybe that firm's appellate division handles it from here on out. Maybe it's a different firm. I don't know, but it's also expensive to continue the litigation on the defense side, but not as expensive as a verdict like this. So we'll see what happens with that. But I just wanted to go over a few of the technical sides of this when you get a giant verdict like this. Like, how does that work? And now I've also seen this question, what does the lawyer get? Well, what's interesting is Florida has some rules for lawyers on contingency agreements. And you can see that the rule at the top is after filing of an answer, which of course that happened in this case, then you can get 40% of a recovery up to $1 million, 30% between 1 and 2, and then 20% of anything over that. And then below that is a special rule for medical liability. And I think it's even, higher return back to the client at that point. But I think in both those cases, you can have that agreement modified. I'm not sure if you need the court to rule on that or not, but those are the presumptive limits for contingency fee agreements in that state, or else the rules say they should be viewed as clearly excessive, but there are some ways to get around it. So if you wanted a guideline versus just seeing what you see on the internet of 30 or 40%, which is, a general rule for these things in many kind of cases, I thought it was interesting that the state has these kind of rules in place. Yeah, there's a wealth of creative, handy people in Arkansas. I don't think anybody can doubt that. All right, let's look at another civil case, which is Meghan Markle. Why? I don't know. Is this my reincarnation that in a past life I did something bad and I have to see this on social media and it stays in my brain until I say something about it? That's terrible. I must have done something really terrible. And if you're watching this, you did something terrible. So I did do a video on Meghan Markle at some point when her case was in the early stages. I should say her case. I guess it's half sister has sued her for defamation. And early in the case, they're trying to get the judge out. The attorneys are trying to get out. They're trying to get the lawsuit thrown out. Everybody was trying to kick everybody out of the court. Was what was going on early in the case. And then I never looked at it again until the other day when I see they're on their third amended complaint. And you see Harry down there. I think he should practice this pose a lot. He lives in a world of drama that he, I guess, chose, but there he is. Anyway, so the half-sister is saying, hey, Meghan in her, rise to stardom or whatever, was taking time out to defame me on the way up, accusing her of being a troll and other things that you can read in the lawsuit if you want to. So 2 counts of defamation, one directly and one by implication. But the court was kind of skeptical of this after the second amended complaint was dismissed. So Meghan Markle's lawyers won that battle. But the court said, I'm gonna let you replead some of these claims again and see if you can meet all the elements necessary to at least get the case moving. So they did that. Her lawyers did that. And of course, Meghan Markle's lawyers filed a motion to dismiss that. And then the court has heard that and will make a decision on it. And if the court decides, okay, these are good enough, then that's when you get some action going on in the case. So I'm sure Meghan is hoping that her lawyers win this one, because if they do, that's it for this case. And the Samantha Markle would have to appeal or something to try and get this reinstated, because the court said this is the last time we're going to let you amend it. But if Samantha's lawyers win, this is more drama for Meghan. So we'll see. Yeah, 20% of $200 million is not bad, except, and I agree. Except, of course, remember right now it's 20% of zero, because they are potentially years away from getting any check, and they've been working on this case for years. So you do see in the paper sometimes the ultra home runs that these guys get, but the life of a contingency fee lawyer in an ordinary basis can be quite a cowboy style life, because you don't know when you're getting paid unless you have such a flood of cases that they're constantly settling, which you can with small cases. If you put a lot of effort into a case, and that often involves you fronting the expenses for your client because they don't have the money for the depositions, the experts and things like that, then you're putting a lot of things at risk, because if you don't win or you don't ever get this money, your time's gone. You can't ever recover it. So sometimes a big case makes up for maybe a big loss that you had somewhere else. Having said that, put your comment back up. 20% of 200 million is not bad. And I agree, this is ultimately going to be, I think, a success story for these guys, but it depends on what the eventual payout is. But Great job by the plaintiff's team to win the case as they did. It's not easy. It's not easy to put that case on. It's not easy to defend it. And the plaintiff side did a great job, I think. Well, that's a good point that my wife is pointing up here is apparently there were these waivers in some of the cases I think that we're dealing with when the court was involved, having some kind of custody issues and this, that, and the other. There's these waivers that if you want to get your kid back, you sign this and you can't ever say anything about it to anybody or do anything. Yeah, that didn't sound good when we saw that. It did not sound good. And none of it sounded good for the parts of the case I listened to. I didn't see all of it, but I saw one nurse for the defense, so I thought she's a really nice person. And the other ones maybe weren't bad, and some of them maybe were, but they all seem to be there to let you know how great every thought they have is and how horrible anyone is who thinks anything to the contrary. And, they could have worked on that a little bit. So anyway, all right, so this is back to our friend Harry here and his life. So you can see at the top, this is when the federal court, because this is a federal case in Florida, threw out Samantha Markle's case against Meghan Markle and said, I'm not going to let you bring anything from this Finding Freedom book. That's with prejudice. That's what that means, is you can't refile it because you can't plausibly allege that Meghan Markle published this book. But we'll give you one final opportunity to replead claims about the CBS interview and the injurious falsehood. So there you go. So the third complaint is outstanding, and we'll see, I guess, if we have to, what happens with that case. I wish they would settle it and Harry and Meghan go back to England and they reach a settlement agreement that all news about them is reported exclusively there and none here. I mean, there are a lot of benefits to being in a sovereign family, but there should be some downsides, like don't be over here. Okay, this is a credit to England for pulling this one off and giving the U.S. here a little slap back for the revolutionary dust up that we had as colonialists years ago. They're still shooting at us in their own way, and so far they're winning this one. All right, so we've had some murder cases, we've had some big civil cases. Yeah, they won't go back. It doesn't look like it, does it? Yeah, that's. I kind of be in favor of giving, let's pick part of this country and give it to England if they want it in exchange for them taking these guys back. But I don't think it'll happen. Let's get some criminal masterminds up in here and take the edge off of some of these serious cases we've looked at. All right, let's go up to Alaska. I don't think this guy's dressed this way because it was cold, but I want to point you to an old saying modified for certain people. If at first you don't succeed, do not try again. Now, this guy tried to rob a bank and it just didn't work out. He was caught. And let's do a post-game review. Because, if you want to stay in a life of crime, you can't expect your first crime necessarily to be your masterpiece. You got to learn. You got to get better. And part of that is critical, honest self-evaluation of how things went wrong. So here's some notes I'm sure he took from his first one, which is, do not put your heist note on a completed form that contains your personal information. That's bad. Maybe someone else's information, but your own, because the police probably would check up on that. So that's a thing. Let's put that in the box. Let's don't do that again. It's suboptimal. First time mistake. Okay. When you get the money from the bank, you're almost home, right? I mean, that's what you wanted to do, was get the money from the bank. But another important component is to get away with the money. So maybe sitting outside the bank on the curb counting the money you got until the police get there that's maybe not the way to do it the next time you do it, right? So those are some faults, some flaws, room for improvement, some TQM. So this guy goes back and robs, I think, the same bank again. The second time is not the charm, and the early bird does not get the worm, because this time he showed up not with a completed form, but with a note. But he got there so early, the bank wasn't open. So he was banging on the doors and things, trying to get into the bank, and the security guard comes and says, we're not open. And he says, I got to give you this note. Passes the note through the crack in the door, which says he's holding up the bank. And so then the security guard's like, I'm going to be calling the police and you can't come in here. And so this guy sits around the bank until the police get there and they arrest him again. So I feel like maybe he's given it a couple of shots. Why not try something else in life that doesn't involve crime, because it may not be his thing, but I think maybe there is also something wrong with this person. And then one to close out with is Oops, I put that out of order, but that applies retrospectively to this guy. But also this guy. Now here's the first guy, he had some flaws, right? Like he was trying to get something done, steal money from a bank, but he didn't plan for the contingencies, like the police coming to the bank after you rob it because someone calls them. And you should think of that, but he just didn't, right? There's no college course for this. Well, some people are just born good at it. And here's one right here. A foolproof plan. Heads, he wins. Tails, you lose. Because he was caught breaking into jail. He got stuck on a razor wire on top of the fence, as you can see in the picture there, and was apprehended by the police breaking into jail. So, he's getting what he wants either way. And when asked why he would be doing this, he had friends in jail, and he said he missed them. He was on drugs, wasn't thinking right, and wanted to go see them and thought he'd break into jail so he could spend some time with them. And maybe this had the happy ending of him getting to spend that time with his friends in jail. But a better plan here, because he aligned his objectives with that of law enforcement, putting criminals in jail. And by doing that, he created a win-win situation. So he doesn't look maybe so happy in his shot down there, but he's not so sad either. So if I were going to a seminar, I would pick this second guy because he at least can get you to a feeling of success. So, all right. And that Alaska is crazy with crimes. That's a place I've never been. There's not many people there, but I guess they have their share of criminals up there. I know they've had some bad ones. All right, so that's our dumb criminals of the week and major case updates. And I did see the request last time to look at this eye dropping case, but I just haven't seen enough of it to say much about it, except for I did hear something about the defendant saying that the lady who died from the eye drops, she'd like to drink eye drops in her drinks. And I'm thinking, you went to the Adelson Institute for insane defense theories that no one's going to believe on this planet. So I think she's going to be reaching soon a guilty verdict that she will hear. That's what I think. So, well, you're from Alaska. That's awesome. And not, well, look at that. Yeah. Do not commit these crimes up there, or at least do it better. Yeah, he probably is glad to be off the razor wire. You don't want to be hanging out on that. That's dumb. All right. So that is, I think that's it. Let's find this thing here. All right. So that's a couple streams in 24 hours. That's a lot for me. And I appreciate everybody coming by and hearing about it, and let me know what cases you'd like to hear about. If I can get into them and get information that's something helpful, I will definitely try to do it, as some of these cases are wrapping up. We'll see on Adelson, I suppose, whether someone else is indicted in that family or not. But anyway, that's it for now. And I hope everybody has a good weekend. Thanks. Bye.